Hello. Good morning. Dr. Bharat Swadkar, the president of the today's function. Dr. Rao, the erudite principal of this institution. Dr. Puttaballi ma'am, your teacher in the classroom, Mr. Krishnan and Mr. Zadav, and my young friends of this college. Friends, I was just thinking as what is the topic on which I should talk. And sir told me, sir, there is a right of liberty of expression of thought. The moment you talk anything, any nonsense will do in this college. So today I am thinking of talking on the. Have you seen the picture? Baby's Day in house and Baby's Day out. What is that? There are two series, I suppose. Baby's Day in the what is their house? What they call it? One is Baby's Day out and one is in the house. There are two pictures. Anyway, we are concerned with Baby's Day out. Now, I am going to talk on a subject of babies, the young lawyer's day out in a practice today. Now, when you pass out from your law degree, you get your SANAR enrollment and then you come out. And fortunately for you today, there are so many things your curriculum has provided you, moot courts, these elocution competitions, where you know how to express yourself. In our time, moot court wasn't a very rare thing, once in a year. It was not in a part of a curriculum. Then some few students will go there. 95% who are feeling shy of it will not go there because they were all from different walks of life. So the basic hurdle to them was to express themselves. Most of them were from vernacular medium, most of them from Marathi medium, Jilla Parishad schools and all that. The first barrier they faced was a language barrier. Now if you want to be in a practice, you must have good command over your language. Unless you are able to express what you want to say, you will not be able to say what you want to say. So even your thought may be good, but you will not be able to say what you want to say. So therefore, in order to have a good practice, a good profession, even as a lecturer, you should have good command over the language and appropriate words. Now how do we go around it? There is a trend, we want this in this language, we want this in this language, it should be, that is all incorrect. There is only one international language and that is English. You should have good command over the English language and you should be able to express only and only in English language. If you are not able to express yourself, you see, district court, they argue in English. Unless somebody says, no, I want to say in Marathi, the judge won't mind, but you should. High Court exclusively English, Supreme Court exclusively in English. So if you want to be a lawyer, a good lawyer, you should be able to speak good English. Now how do you speak good English? It is not that in Elizabethan English you should have that what the Shakespeare said in Hamlet and what somebody said elsewhere. No, you should be able to communicate what you want to say. And if you are able to communicate what you want to say, then you will be able to communicate your thought, your arguments to a judge. One who is sitting there, you will be able to make out your point. Now what happens is, if you are not good in your language, that is English, then the first thing that happens in college is students fight shy of appearing on the stage, going to the moot courts, taking part in elocution competition, involving themselves in debate. There is no exchange of thought. As a result of which, you get an inferiority complex. Sometimes even you may lose a good girlfriend also because you are not able to talk to her. Hi baby, how are you? आणि मग मराठीत म्हणायचं कागळ कसं काय चाललं? नेक्स्ट वर्ड ऑफ डिस्टन्स. The girl will say, अरे तू आताच भिडून आला का? This is the difference that makes if you have a good command over the language. Don't practice it, I am just telling you. Otherwise you say, silly. So you should have good command over the language when you come in practice. Now my request to your president and your principal is this, whether you like or not. The moment you enter in the college gate, you will speak only and only in English, communicate, right or wrong, correct or incorrect, but you will communicate only in English. You will not speak any other language. If you speak, it is a taboo. The other student will boycott it. Please speak in English. Even if you have to talk to your boyfriend, please speak in English. So that at least he will be instigated or rather motivated to speak in English. English is any language. What English? Any language. Because it's a foreign language, but unfortunately we are a colonized country, therefore we don't have any common language. We are trying to impose Hindi, it's all right. But we have Kannada, we have Marathi, we have Telugu, we have Tamil, all these are like foreign language, German and French. So in order to learn English, you must be able to speak English. First, learn to speak even wrong English, doesn't matter. Because what I speak in Aurangabad may not be in Umarga, because the accent changes as the way you speak Marathi or your mother tongue changes. So, in order to be a good practitioner, in order to learn the law, you should have good command over the language. And then only, unless you improve your English, you will not be able to sustain either in service or in practice. Now, there is one big advantage to you. Just try this, if you can, which I am trying last so many years because I was not knowing. You have your mobile phone. Most of you have your mobile phone. The moment you hear some new word, open your mobile dictionary and find out. Now please tell me which is the word which you have learned last 1 week or 2 weeks on television. Which is the word you have learned on television last 1 week? Just see your aliveness to the situation. Akka. उसके आका के आका है, ये उसका आका है, वो उसका आका है. What do you mean? Open your mobile and just tell me what is your आका. AK means what? So that is a new word which you are learning. Now why I am telling you? Suppose tomorrow there is an FIR lodged, and in the FIR it says that an XYZ is the akka of ABC. Now you will say, what is this akka? Is it akka or it is akka? But in order to know as to what offence has transpired, you have to be live to the situation in the newspaper, in media. You must learn this because in the dictionary, English dictionary on your mobile, akka word is there, alias. So that word is important. The moment you learn this, you have to have a knowledge of this word, because tomorrow in any FIR, first information report, somebody will write ABC he is a akka of so and so, so and so. So unless you know this, what is akka, that is a mentor, you will not be able to say something in your petition or even bail application or otherwise or in cross-examination. So you should be also, because you have a benefit of having technology today, you should be able to utilize it. And therefore my request to all of you is this, that use technology and try to learn more and more correct meaning of that word. You can speak incorrect English, you can speak correct English in the beginning. But as you go on improving it, many times today myself, when I see that the meaning of this word is XYZ, but when I open that mobile, I find the correct meaning is something slightly different or totally different. So please open your mobiles and try to learn the different words, because in law there are many words, may and shall. Communicate. Now communicate word has 3 different meanings. Suppose some lady is passing by, I can abuse her, 1. I can sign her. So communication is by different methods. Abusing by words, abusing by sign, 354. So you have to fit the offence or unfit the offence in that particular category. So you must be able to know what is communication. Now in order to get the communication skill, what you must do is, first thing is try to enter even in canteen, in classroom when teachers are not there, or anywhere else you get an opportunity to enter into a debate. Debate doesn't mean that quarrel. Argument over any other word, something is good, bad or ugly. You must read, I don't know whether current writers I don't have, but in previous days there used to be this Arthur Helly and then others that they have written that airport and carpet beggars and all that. And they used to use all nasty words which were prevailing in the market. They called it slang language. So those words were used in the books because the FIR or some documents are written in the slang language. So you must have knowledge of that. Now don't say that they have used the very dirty words. In law there is nothing dirty and nothing good. Even for a woman lawyer you must know all these things because you are going to face the situation. What is actually happening in life. So you must read those novels, and those novels are also according to me subject to corrections. They give a different version of life. For example, if you read Fountainhead, it's a novel which is written on the basis of an architect's life. One architect competing with another, how one building is coming up and how other building is not good or other standard and standard house. There is another novel which is known as Final Diagnosis. It is a fight between two thoughts, a young doctor and the old doctor giving treatment to a baby child about a particular ailment. So what you get is that not only that you learn about what it is, you learn about different words, but you also get set your thought process of a fight between young doctor and the old doctor, a fight between a treatment being given to a same baby child by an old doctor and fight between a young doctor who is giving. So these are thought processes which evolve in your mind, and those thought processes are to be crystallized in your argument, and then you put up your argument. So communication skill is the first thing where you should have command over the language. Now I'll just give you one example where a young lawyer, he got his first brief, and in small court the accused has come to him and they told him that no, I have been issued summons by the magistrate, and the magistrate now I have to go and appear before the court. So lawyer read the brief and told him, look here, now your evidence will be taken, your statement will be taken. So whatever the judge asks you, whatever the prosecutor asks you, you have to only say, what is your name? Baba. What is your father's name? Baba. What you have done? Baba. Everything Baba. So the judge says, this fellow nonsense, he won't commit this offense, acquits him. The lawyer comes outside the court and he says, what about my fees? The accused says, Baba. So this is the way there are practicalities in life. So first thing is, I am again repeating it, that you should have a communication skill having command over the language. Now the second most important aspect which I want to point out to you is that after you learn the language, you should have boldness. Boldness means what? You are seeing me speaking here, but when I was a student of junior BA, there was one elocution competition that on some economic topic of India at that time in 1973 or 72, something like that. And India Today was there, so I read something from India Today and I thought that, I will also participate. And the classroom was there and my turn came. So when I went on the dais, somehow or the other I started shivering. All are sitting there, some girls are there, what they will think about me. My friend is there, what he will think, my roommate is there, and in all this thought, who will say what? I lost the thought which I had to communicate. And in that, what happened was that I was saying India is going this way for economic development, India is going this way, and I was going some other way. So I was not able to concentrate on my thought. So in a practice, you should be bold enough to put your thought across the table, while arguing, while in office, anywhere else you have to put your thought, you should be bold enough to say, yes, this is what I think. But before that, you must be able to sure that what you are going to say. But that's a different case, that is a study which you have to make at home. If you are not bold enough to say this, sometimes you may lose a case because you thought that no, whether I should say this or I should not say this, I should say this or I should. Many times not saying is also good, but then you should be bold enough when you practice in law, either in arbitration or anywhere else, so that your inferiority complex is removed and you are able to put your points good. Now sometimes what happens, some lawyers have bad habits like me. I will try to overpower, Bharat Swarkar madam knows it. I will try to overpower the other lawyer. No, my lord, he is not talking good, this is what it is. If there is some my lawyer, what is this now, he is saying, why should I say something? But let me finish and you can put your point across, but never take your step back. You should be bold enough to say it is all right, my senior colleague or my colleague or whatever it may be, learned colleague has said this, but I am going to say this, that he is not correct, or he may be correct, but this is the other aspect of the life. So be bold enough in life to say something. Now another important aspect in life is that the baby's day out is that first thing you want to know is that from where to get the dress, which coat you should have, or ladies, which dress you should have, what type of different dresses they are there. Now in the High Court Appellate Side rule, there is a specific chapter which is there. If you get some time in your library, please read that. That is chapter number 32. And it talks about legal practitioner. And in that, there are specific rules which are framed for the dress of a gentleman and gentlewoman. There are colorful dresses also, but dresses are mild, not very bright. So, when you come in the court, make it sure that you are properly dressed. I am not saying that well dressed, you should have only Raymond suit and all that. No. But you should be properly dressed. White shirt, band if you are in High Court or Sessions Court, coat, gown, everything. And then, because your dressing sense distinguishes you from others in the courtroom. One. Second thing is, just imagine, it happens with everybody. You see, this is the collar for men, I am telling you. This is the collar. There is a button inside. Sometimes it happens, it is broken. Now you go in courtroom and you tie your band here. But it becomes very uncomfortable here like this. Then you are arguing. You are saying, yes, yes, my lord, but yes, you are trying to cover the button. Yes, my lord. Yes, my lord. My yes, yes. No. Dr. Bharaswatkar is not correct. Something you make submission. These are very small things in life. You say that, sir. So dress code, you should be properly dressed in the courtroom. And that dress should be in such a way that you are comfortable. Otherwise, your waist is 39 and you are wearing pant of 25. Make will everything different. So that is one thing which you must have. Ladies, I don't want to make any comment, otherwise 354. Now, when my young baby goes to the court, the first day he comes with this, like this coat and all that, and he waits for his senior. And senior says, look here, you go in the court, XYZ court, and you mention the matter. Now, he doesn't know what it is. It is a writ code, it is a criminal code, it's a second appeal code, it's a first appeal code, it's a criminal code, it's a civil revision application, what not they are there. Please make it sure that when that circulation, sometimes seniors also, sometimes there is a short of time for some reason, traffic and all that. But you must know what you are going to mention it. By and large, once or twice it can happen that sometimes seniors also don't get time. Suppose you are told to mention in a writ court, division bench. Now there are rules framed under the High Court Appellate Side rules, which matter will go to the division bench, which will go to the single judge civil matters, which matters, murder matters will go to the division bench criminal, some matter which are less than 10 years punishment will go to single judge and all that. Now you are given a matter and you are told to go to the division bench of civil. You must know what is the matter about. Otherwise the judge will say, sir, I want circulation tomorrow. He says, what is the matter about? And then he will start looking here. Then what is it? Then judge will say, if you don't know why you are asking circulation. So embarrassment is there. So try to avoid sometimes. Many times it happens that you don't get time, but try to avoid an embarrassment when you go to the court. Now in court, when you are appearing on a first day, whether you are from Elizabethan English or you are from convent, you are CBSE or anybody, very few of them are confident otherwise. First day mentioning creates a lot of problems. So I am from vernacular medium, so my accent also differs. Many times there are good convent students, so they will correct me. So we used to literally mug it up and omit it out. What is it? May I, with your lordship's permission, mention a matter for circulation on so and so date, and I want to get bail in a criminal appeal. So this repeat like mantra, and then go there. Now first day what happens is, may I, with your lordship's kind permission, mention a matter for circulation. Wait, what is this happens in life. Nothing wrong. It will happen with you. It has happened with me. It has happened with you. Nothing wrong in it. Because this is all situation, a learning situation. What you learn in law colleges today is far better than what we were learning. Nothing, no practical. Now one day I will tell you my own experience. My senior Mr. A.V. Sawan, and I must tell you, he is a student of this college. He subsequently became a Chief Justice of Kerala High Court. So I joined him in 1978, and 1982 he was appointed as an Advocate General. Now most of the chunk of the briefs which were against the government or government authorities. So once he becomes Advocate General, he can't appear in the matter. So myself and other two colleagues were there who used to manage the Delhi board. So what happened, one day I had to appear in A court, mention it, and run in B court. There also I had to mention. So there was Justice Jagirdar there. He was very disciplined and good mannerism. He will not tolerate anything. So since I wanted to run, so what I did was that I was second in queue. The moment he came, his peon pulled the chair and he was about to sit like this. I started, may I with your lordship's kind permission mention a matter for CRA admission tomorrow. He was quiet. Glass here, glass there, this, and he said rejected. So I was very fumbled, but I had no other alternative. I walked away. Somebody told my senior. Then I went in other courtroom and there the queue was weak, so I got admission. In the evening when I came to the chamber, my senior told him, "Arey, you have committed a very wrong thing in a very right court. He is very disciplined. He will not tolerate any hinky-pinky." So he says, you have to observe your senior. Some seniors in barroom, how they come. Because they are seniors, they will get the first place to mention. So let the judge come. Sit in the chair properly. Let him put his glasses or let him be a little comfortable. And then he will ask, yes, Mr. Dorde, what you want? And then you have to tell him. If you don't do this, and then he has told the name of late Mr. Paraspe, who was there, then other lawyers also. So baby's day out in the court is that when you mention a matter, make it sure that you maintain a poise, you are comfortable with the judge, whatever you want to say, you communicate him. Mentioning the matter, you must know the matter because most of the time. Second thing is some judges are very easy. Young boy mentioning the matter, all right, granted. Some judges are other way around. Yes, what is this matter? When you have filed? What is the subject about? What is the urgency? So just in order to make that young lawyer speak or communicate, they will ask you the other way around. So when this happens, this is what I told you, the boldness and the command of language comes in. You have to say, sir, this is what it is. Suppose the court, if you don't know the brief, tell the court very friendly, sir, I got the circulation note hurriedly. I was not able to say, so I am tendering on it. I will tell you how it happens with me. It has happened with me. When my senior became a Advocate General, I used to get early in the morning at 5:30. That time there was that kerosene stove and I was staying in Bombay alone. And then I used to put 2 eggs for boiling. Brush, washroom, bath, come back, take 2 eggs, go walk 10 to 15 minutes across the Ghatkopar station, take 3:15 bus from Ghatkopar to Bandra, go to Law College, you will reach around 7:15, 7:20 the lecture starts, 7:20 to 8:21 lecture, 8:20 to 9:20, 9:30 you take 4 limited bus, you go to Fountain. If your bus reaches, 4 limited bus reaches to Fountain from Bandra at 10:30 you are lucky. If traffic 10-15 minutes means 10:45, if you get down at Fountain, you have to rush to the court, great desktop, and then you have to say, sir, what is it? Then standing queue like this. Then you will say, take this, take this, take this. Or you are senior in chamber, that means junior one who is senior in chamber, he will say, Arey, ye tula admission karal. So it is told to him, he will say, you go and mention it. So you take the circulation note and go and mention it. No tea, nothing. Once the court started at 11 o'clock, because in Bombay High Court, there was a tradition that if you see the court number 52 in Bombay High Court, principal seat, in court number 52, the Chief Justice of this court sits. And just behind that there is a balcony or corridor. There all the judges will meet sharp at 11 o'clock. They will chat there something, how are you, weather is like this, 2 minutes, and then they will go to their seat sharp at 11:05. So you have to be in the court before 11:05. So when you rush to the court, one of the most important things in life is that you have to be in the court before the court takes the seat. Whether you are first in the row or whether you are last in the row, but never take a chance. They come at 5 minutes late, he comes at 5 minutes. Because there are many things which happens. There may not be anybody mentioning on that day. And if you go a little late, courts have already started functioning, there is no mentioning in it. So another important aspect is the discipline about mentioning, the discipline about attending the court. You must be in the courtroom before the judges take their seat. You know many things. For example, there is some criminal matter going on or some civil matter yesterday. Some judges say that we will take that matter first. So estimate that 1.5 hours it will take. So you know what is to be done, mentioning and all that various things can be arranged before you go to the courtroom, before the judges take seat. So another important aspect of the matter is that one is mentioning, second is going to the court well dressed or properly dressed, third is going in the court hall before the judges take seat. Now why another important aspect going to the court hall earlier is there. Suppose there is some matter today for hearing for me or my senior. The other side comes and tells him that my senior is today not free, we are going to take time in that matter, shall we mention? Or we are going to mention it. So this communication is also done if you go in the court hall before the judge arrives or before the court takes the seat. So this is another discipline. So before going to the court, mind value, these are three important things for you. Time element. Need not be that you should have brief in the court. Even if you don't have brief in the court, make it sure that you go in the courtroom when the court begins. It is just like school. Now the next important aspect of the matter is that when you go to the courtroom, when you go to the court, what happens? Many times, chai piyenge, go for smoke. What is there? Oh, that matter will take 1.5 hours. Why sit in the courtroom? Somebody is arguing with. No. Two things in life. If you want to be a good lawyer, I am not saying best. If you want to be a good lawyer, then you must sit in the courtroom, not in corridors, not in canteen between 10:30 to 1:30. Or if you don't like sitting, go to the library. But don't monger here and there. Because I will tell you, suppose today I am sitting in A court, court number 4. And my work is down there, suppose serial number 20. Somebody is arguing a matter at serial number 5. I am just sitting in the court. And he cites an online judgment which has been decided 2 days before or yesterday. And he says, sir, this is the case law which the court has decided. I have nothing to do with that matter. But after 1 week, 2 weeks, 2 months or a year, if the luck smiles on you, I am repeating you, after 1 week, 2 weeks, 1 month, 1 year, if the luck smiles on you, you may have the same brief in which same point is involved. And when you are taking notes of the fact in your chamber, you will say that so and so XYZ, the point he has argued. And this is what it is. It becomes very easy. You can assure the client you have a comparatively good case, I can argue this. But forget about the luck smiling on you. Important aspect is you have heard something about the law which the Supreme Court has decided, and it will help you to interpret any other law than what you are doing. Instead of mongering in the lobby or corridors, this is the best way. That is another thing you must keep in mind. Or sit in the library. You have got a good library, so in also our High Court or district courts have also good library. Now these are the mannerism which you must maintain in the court. Next is, many times what happens is, when you have prepared a court, I am telling about myself, what used to happen. When you have prepared A point, B point, C point, the moment matter is called out, you say, sir, this is about the service matter, my client was working as an engineer, he was promoted to so and so. But in High Court, most of the judges have read the brief. But if you recite this like a poem or any other thing, that you have mucked it up and you want to omit it out, it will not help. You must be able to communicate to the court whether the court is listening to you at that time, because they may say that this is the matter yesterday we have decided we will issue notice. If they are discussing two judges in this and then you are arguing this matter, it will go overboard. So you have to first be watchful as to when the matter is called out, what is the reaction of a judge. Look into their eyes and then start arguing the matter. Many times it happens that you don't have to open your mouth. They will say that you have seen the group of matters, this is all similar like this, we will issue the notice. If you are in the interim relief, they will say this, otherwise they will say notice to. Or many times they say we have rejected this matter yesterday, you argue if you want to argue, otherwise you read that judgment and come back. So this will also, because what the judges are trying to do is they are trying to save their time. And you want to justify your time because your client is sitting there. But then in that particular case, you have to be little reasonable. Sir, 2 minutes I will say something and go. So when you argue the matter, be attentive to the court and don't just start that you have taken A, B, C and D points. So therefore you must all put all D points before the court. So that is what happens when you are arguing the matter. Then another thing is that you must follow your seniors. The first and most important thing is that don't take it otherwise. But because of this technology, everyone thinks that I am a perfect lawyer. Drafting of petition, one format is there, you fill in, file it. Criminal appeal, format is there, fill in, file it. No. You must attend some senior's office at least for 2 years minimum, so you know basically that there is at least A, B, C word. If you attend for A to Z, still better. I have attended my senior's office almost for a period of 11 years because I was compelled because he has become senior advocate general. But you must attend there are many things which you learn. The tricks of the trade. Tricks means not bad tricks, but how to talk to the client, how to handle the brief, how to arrange the brief. Tomorrow you have 5 matters in the court, how to arrange which court will reach fast, which court will not reach. These are all things. Drafting, then issuing notices, various things you learn. But then before that, also you have to be at senior's chamber before your senior comes to the chamber. I will tell you, I used to stay at Ghatkopar, but when on the day I not used to have lectures. I used to be from Ghatkopar to Nariman Point, I used to be at 8:30 in the office, morning, because there are many cases, and also evening 5:30 to 8:30. He will allow us, Mr. Sawant will allow us, even if you have to be a little free earlier, he will say, Mr. Dorde, that day in that matter we have seen something, just check it up. He will not allow you to go before 8:30. Another shuffle the books. Then you have to tell, sir, no. Yesterday that Justice Dharmadhikari was telling some matter, he was reading some judgment. 8:30 you come down, take 123 bus, come to the VT station, take VT station to Ghatkopar 40 minutes, from Ghatkopar walk down to your premises 10 minutes. Then come home, take food and when I was bachelor. So this was right from 5:30 in the morning till 10:40 or 11 o'clock, this was the, but unless the last thing is that there is no substitute for hard work. Even if you have to learn the language, you have to do hard work. You have to learn the subject, you have to do hard work. You have to practice, you have to do hard work. And there, I subject to your principal and president telling me there is no medicine which is substitute for hard work. That you gulp it up and then you get something done. No. So that is another thing in life. Now, when you go to the court, the important aspect is that you have to watch some of the seniors, how they interact with the court. When they argue, where they stop and where they begin. When the queries is asked, some seniors tell, sir, to be very frank with you, this branch of law I don't know, I will study it and tell you tomorrow. Some say they know, some of them are like that. My time, I was observing Mr. Parante, then there was one Venkatraman. He was from Chennai. Now I will tell you, I was awed by him. I was in the original side of Bombay High Court. Just I had gone one day, know what is going on, there is a crowd. So one Japanese ship has made an accident with a Vietnamese ship in Bombay port. So accident has taken place in sea. So international law applies, but this was in Indian sea. So original side Bombay High Court. So Justice Pratap or someone else was saying. And the court told him, look Mr. Venkatraman, your ship has made an accident. So if you want a release of it, because ship was arrested. So if you want to release your ship, you must give the surety back or you must deposit 25 crores. So I thought that now you will say, no sir, 25 crores means what, where you will go. But it was a Japanese company. He smilingly said, yes sir, we will deposit it. So I was you learn to know where the world is and where you are. Otherwise 500 rupees bond, 200 rupees bond, self bond, this bond, that bond. And why I had gone there in that court is because one of my subject in LLM was, I had just taken because I wanted to know news. The air and maritime law was my one of the subjects in second year LLB. So I wanted to know from Mr. Venkatraman how he argues in the court. He was only flying at two places. One is Singapore, three places. London was the headquarter of arbitration, and third was Djibouti in Africa or somewhere else. These are the only three places in international law where the arbitration regarding any plane accident, any ship accident is to take place. But this is all knowledge you get. Even if you get today and I am telling you it has nothing to do, but it's just adding to your figures to your knowledge that there is an air and maritime law and this is how accident takes place and where it should go. So that is how you must follow some of the seniors whom I was lucky enough to have Mr. Sirwai because he was then Advocate General till 75. Mr. Palkhiwala, I had seen him arguing in the Bombay High Court. Then Mr. Parampe and all these people, Mr. Ashok Desai, they were all arguing in the court and I had actually seen them in arguing. We used to sit in the court also when we don't have any other work, then we were juniors in other courts. So that is the thing that you should follow and you should watch apart from remaining present in the courtroom. You should watch there. Then when you attend the court, you should be regular in the court. Like, okay, today I don't have brief. Kya karenge jaake? Movie. Or we'll sit with some friend or we'll do something. No. Please attend the court regularly. Again I am telling you, when luck will smile on you, nobody knows. Somebody is not there. Dr. Rao is absent today for his relative's marriage. Somebody will come and say, sir, can you take my brief? All right. You can have luck with him. But attending court, apart from this aspect of the matter, develops a discipline in you that you are in your profession and it creates a very good impression with your colleagues also as well as the clients that no, this lawyer you go at any point of time, you have to be, he is available. So that is another thing which you must attend the court. Now when you attend the court, between 10:30 to 1:30 in the High Court and 2:30 to 4:30 you do anything. But in between, you can talk all nasty, nonsense thing, dirty, good, bad, ugly, with your friends in canteen, in your bar room and all that. I will tell you one incident. Do you know Barrister Siddharth Shankar Ray? Any one of you? He was the Chief Minister of Bengal. He was practicing in Calcutta High Court. His wife Maya Ray was also practicing. They have passed out from bar at law in England. And she was the only lady lawyer in the bar room. So what used to happen whenever she used to go for taking water or something, because in those days, 1940, 50 or 60, I don't know, no canteen, no ladies, she was the only lady. And what used to happen when she passed by, all these so-called gentlemen lawyers, they were all discussing on their table all good, bad, ugly things. The moment she used to pass by, they used to like this. Shut up their mouth. So one day she said, she was from London, so she knew all these things. So she said, why is it that you are distinguishing me as a woman, and every time you are. So she has told one day in the bar that one day I went to them and I told them another non-veg joke. And from that day onwards, they have not started distinguishing me and keeping quiet in their own. But this was only between 1:30. Don't try with your lady friends. Otherwise, Dr. Rao will never call me here again. But this is a part of life, I am telling you. This is actually, when she was old, the only lady lawyer in the bar room, just imagine. So when you come to the courtroom, you have to be regular and you have to pay your time. With this, friends, I think it is already 10:15. I do not wish to take your more time. And no matter what you is that, this profession is a very noble profession. Be forthright. Never commit any mistake and never take advantage of anybody's situation. Time will wait for you. But once you commit a mistake, time will not wait for you. Hard work is the only solution to your profession. And last thing is that if any one of you get an opportunity, go in Bombay and practice there at least for 2 years. You know what the life is. Here, you go across the road, you get a flat. This side, High Court, go in the flat in the evening, no transportation, nothing. One of my colleagues in my chamber was coming from Borivali, Delhi to the High Court, and 8:30 along with me at 9 o'clock, he was going to Borivali. What time he must be reaching, just imagine those things. So, these are all things in life. I hope that, and I am thankful to you for listening me patiently. Thank you very much.